Andrea Wainwright was having chemotherapy. While she was off sick, her employer permanently appointed somebody else as head of installation, the same title she held. Then the business announced its new structure to the team. Wainwright wasn't shown on it. She hadn't been consulted, and then LinkedIn sent her a notification congratulating the colleague on the new role. The audacity. Imagine finding out something has changed around your own career because LinkedIn is asking you to congratulate someone else. And somehow, that still wasn't the full story. Wainwright asked her employer what was happening. She was reassured that her own role had not changed and that the colleague was leading the department for now, just for now. Except the appointment was permanent. LinkedIn had revealed the appointment. It hadn't revealed that permanence. Wainwright learned that later permanence piece from the colleague, not the employer. Years later, the final remedy judgment would record a total gross award of $1.22 million after tax grossing up. And that award reflected the wider litigation and losses, not one LinkedIn notification or one isolated conversation. But before this becomes a cartoon story about a company replacing a woman because she had cancer, there is something important you need to know. Cennox, the organisation, had a real operational problem. It needed continuity and was trying to retain a valued employee who was considering leaving for a competitor. The tribunal did not find that the reorganisation was invented because Wainwright had cancer. And that is precisely why this case matters. Because the question is not whether a business is allowed to keep operating while somebody is seriously ill. Of course it is. The question is, where did that legitimate operational problem become discriminatory treatment? And how did the organisation end up with a $1.22 million gross award years later? That is the part underneath the LinkedIn post. Wainwright had worked for the business since 2002, and in August 2018, she was diagnosed with breast cancer, started a period of sickness, absence, and underwent chemotherapy. Cennox did some things that were generally supportive. It gave her 6 months of full sick pay when the normal contractual entitlement was 2 weeks. That matters because organisations are rarely neatly divided into kind ones and cruel ones. The same organisation can support somebody in one decision and remove their voice in the next. Because while Wainwright was absent, a colleague stepped into the operational role. That makes sense. Installation still needed to happen. Clients do not disappear because a senior employee was ill, right? There was a genuine structural review. The original tribunal found that review would have happened even if Wainwright had not been absent. And a colleague covering the work was considering leaving for a competitor. And Cennox regarded losing her as a serious blow. Cennox's position was that there was enough work for 2 heads of installation, and it decided to appoint the colleague permanently. That is the employer's strongest argument. Continuity mattered. Retaining a valued employee mattered. The reorganisation was not found to be a fiction invented because Wainwright had cancer. So where did it go wrong? At the point where a genuine business problem was treated as through, it cancelled the affected employee's rights to be part of a consequential decision. The permanent appointment was made in November 2018. The team was told about the new structure. Wainwright was not included in that communication, and the organisational chart did not show her. Then LinkedIn did what LinkedIn sometimes does. It told the person affected by an organisational decision that the organisation had made it. She saw a notification congratulating the colleague on starting a head of installation position. Wainwright asked HR what was happening. She was told her role still existed, that the colleague leading a team for now, and later that she was still head of installations, and that had not changed. But the colleague's appointment was permanent. The tribunal regarded those communications as misleading. It accepted that they had been clumsy while meaning attempts to avoid worrying someone during cancer treatment. So it was well-meaning, right? There was well-meaning attempts. And this is the bit organisations miss. Good intentions do not make an incomplete version of reality complete. Trying not to worry someone is not the same as giving them no meaningful say in a permanent decision about their working life. In fact, the organisation tried to reduce her worry by reducing her information. Let's say that again. They tried to reduce her worry by reducing her information. And as she was told, the more everybody else moved forward inside the structure, she had not been allowed to discuss. And the original Employment Tribunal drew a careful line here. It rejected Wainwright's direct disability discrimination claims. It also accepted that reorganisation itself was genuine, but it upheld claims of discrimination arising from disability. It found that permanently appointing the colleague as head of installations, the same title Wainwright had, without Wainwright input, was unfavourable treatment arising from a disability-related absence. It also found that making a permanent appointment at that stage was not justified. Temporary or acting arrangements were available while the structure of Wainwright's position could be discussed properly. That distinction matters because the finding was not you may never cover a whole role when someone is ill. It was not you may never reorganise. It was not even you may never permanently appoint someone else to a senior position. The finding was about the permanence, the effect on Wainwright, the lack of input, and the fact that her disability-related absence was why the conversation did not happen. Now, there is a fair counter-argument. If somebody's going through chemotherapy, involving them in a reorganisation can feel intrusive. A decent manager may think she has enough to deal with, we will protect her from this and sort out the operational problems ourselves. And I understand that instinct, but consultation is not asking somebody to run a department from a chemotherapy chair. And protection does not require describing a permanent decision as through it was temporary, right? The moment the organisation decided the appointment would be permanent, this stopped being only a cover decision. It became a decision about power, status, structure, and Wainwright's future. Her physical absence did not make her materially absent from its consequences. The case then continued, because the Employment Tribunal preserved the successful discrimination arising from disability findings, but said the original tribunal had not properly completed its analysis of the dismissal claims. It sent the constructive unfair dismissal, discriminatory dismissal, and wrongful dismissal issues back to a different tribunal. So in 2024, that tribunal found that Wainwright had been constructively unfairly dismissed, discriminatorily dismissed, and wrongfully dismissed. So by that stage, this was no longer about the appointment made while she was absent. The later tribunal also found that the way the relationship had broken down amounted to dismissal-related wrongdoings. It found that the misleading treatment damaged the trust between employer and employee. The fact that some of the communication may have been well-meaning did not restore the information she had not been given. Then came the remedy. In May 2025, the final remedy judgment recorded a total net award of £872,115.65, and after tax, grossing up to a gross award amount of £1.224861.94. So that was not a 1.2 million punishment for one awkward HR conversation. The figure included substantial past and future financial loss, interest, injury to feelings, and tax grossing up. The remedy reasons reassessed future loss over 6 years. In other words, the cost reflects what can happen when one decision changes a person's career trajectory, and the consequences continue long after the meeting, or the meeting that never happened. And here is the bigger organisational reveal. We often behave as though voice belongs to presence. If you are in the room, you are part of the decision. If you are in the office, on the call, replying to email, visible in the structure, you exist. If you are absent, decisions begin to happen around you. The perspective becomes inconvenient to collect. Other people's urgencies become more concrete than your future. They don't stop being stakeholders because they're not in the room. Being absent is not consent. And this is why supposedly practical people decisions can become organisational risk. The organisational question was, how do we keep installation department running and retain a valued colleague? The consequential question was, who gets to decide what happens to Wainwright's role while she is away? Cennox answered the first question. It did not involve Wainwright in answering a second. The gap is a decision architecture underneath the case. It is the gap between temporary cover and permanent power, between trying to protect somebody from worrying and withholding information they need to understand their own career, between a manager solving today's operational problem and an organisation noticing the risk created by how the solution is reached. And no, that does not make every imperfect communication discriminatory. It means the facts, legal test, the effects of the decision, and the reason for the treatment matter. This is commentary on one decided case, not legal advice for yours. Wainwright first saw the appointment through LinkedIn, but LinkedIn was not the decision. It was the receipt. It was the place where the organisation's public reality collided with the softer, incomplete reality it had given the person most affected. So the wild part is not the company kept operating while an employee was having chemotherapy. The wild part is that her absence became permission to make a permanent decision affecting her career without her. And that she discovered the appointment through LinkedIn, learned its permanence from the colleague, and never got the full reality cleanly from the organisation making the decision.